parole. Third is, I would really implore the members of the legislature to look at Miller as an opportunity and not as an obstacle. The response to Miller should not be, good grief, we've got a problem here, we need to fix it. What's a really long sentence, such Attorney General Schuette mentioned, 35 to 50 years. What's a really long sentence we can do to sort of respond to Miller? What's happened in these United States Supreme Court decisions is the law is starting to catch up with the science on the brain. And the law is starting to recognize that, okay, youthful offenders, you can't excuse the offenders, but for various reasons, youth are not quite as culpable. Children should not receive the exact same sentence. Sentencing in America needs to be re-examined to adjust to these realities. And Miller, in saying that Michigan sentencing for first-degree murder is unconstitutional, is an opportunity to look at that. As Professor Thomas discussed, we have a series of interlocking statutes that has resulted in Michigan being an outlier state, being one of the top 4 states in the country in terms of folks serving life without parole sentences. And Miller's an opportunity to look instead at the sort of individualized sentencing scheme and to impose life without parole where it's appropriate, but also to impose individualized sentences where appropriate. The next thing I wanted to talk about in terms of legislation is, and I promise I'm getting closer to the end, is
I'm getting dirty looks from the audience.
No,
just
no,
letting you
fair
know.
enough.
But you are the state appellate defender, so I want to, you've got some good things to offer here.
No, and thanks, and I do appreciate talking about this side of things, but is control of the process. And Representative Heise, you've asked a lot of questions about the federal case and Judge O'Meara, who has said the parole, that everybody should be entitled to parole. We don't know what's going to happen on retroactivity. We don't know what's going to happen on in terms of the appeal of the ACLU lawsuit. Mr. Birch gave a spirited, as an advocate, gave a very spirited defense of the reasons for why Miller is not retroactive. I'm not going to counter that. I'm not going to get into whether it's substantive and whether it's procedural. But what I do want to emphasize is we don't know what's going to happen. The Mississippi Supreme Court, Mississippi, not Massachusetts, the Mississippi Supreme Court has held that Miller is retroactive. The Iowa Supreme Court has held that Miller is retroactive. The Louisiana and Arkansas Supreme Courts have issued, I don't think they have full-fledged opinions, but they've issued orders allowing retroactive sentencing under Miller. Illinois intermediate courts have held that Miller is retroactive. And New Hampshire intermediate court has held that Miller is retroactive. It's correct that the Michigan Court of Appeals in the Karp case, currently under review by the Michigan Supreme Court, has said that Miller is not retroactive, but we don't know where it's going to go. What we do know is so far, the majority of state courts have found that Miller is retroactive. We also know, of course, that a federal judge Judge O'Meara has found that Miller is retroactive, and we're not sure where this process is going to end up. In the Foster Bay litigation dealing with parolable life a few years ago, a federal district court judge said that Michigan's parolable life scheme was unconstitutional. Ultimately, the Sixth Circuit overruled that and practice went back to normal on Michigan's parolable life scheme. But it's important because a stay was not granted, and for a year and a half, give or take, the parole board held very different parolable life hearings that had been held in the past, and far more folks got paroled. It's impossible to say what's going to happen with our state courts and retroactivity, with the U.S. Supreme Court and retroactivity, and with the federal lawsuit. But there is certainly a chance that parole hearings are going to start taking place if there's not a stay, and there's certainly a chance that the courts will impose some sort of process outside of the legislature's control if there's not action. And I would implore the legislature to take control of this process, both retroactively and prospectively, and to not just to prevent courts from legislating from the bench, but also to give everybody finality, so that my clients know what to expect and what might happen in the process, but also just as importantly, so victims know what to expect. and know that here's the process that's going to take place. We're not going to potentially wake up 2 years from now to find out that the parole board is going to be allowed to hold a hearing on this case. It's I think with an uncertain judicial landscape, legislative action might be that much more important. I'd like to conclude simply by saying, and this isn't to point out what's good policy or what's bad policy, but rehabilitation's one of the Miller factors, and it's in doing some research for this presentation, I saw the longest running longitudinal study of violent juvenile offenders is called Pathways to Desistance. It's funded by MacArthur Foundation Research Network, the Centers for Disease Control, and it found that that within 3 years, 91.5% of juvenile offenders who commit felonies reduce their offending capacity and move towards recidivism. This is not to say that obviously you look at a lot more than rehabilitation in sentencing, but it is to say that Miller has given us an opportunity for a new way to address juvenile sentencing in Michigan and to individually sentence folks and to look at these factors.
All right, thank you.
Thank you very much.
Any other questions from the House members? We've had some discussion today about a bill that would provide for a trigger clause, that if the Supreme Court renders it retroactive, that I don't know, certain X, Y, and Z would take place. What are your thoughts on that, briefly?
I think it's dangerous. I think that it moves towards but does not completely cure what is a very uncertain legal landscape. Judge O'Meara's decision talks about the parole process and the unconstitutional lack of parole for youthful offenders. If there is a trigger mechanism saying if the U.S. Supreme Court or if the Michigan Supreme Court finds that Miller is retroactive, then these sentences should apply. It might not necessarily stop parole board action if that becomes federal law. It's so I would say initially it's not guaranteed to work. My second thought on it is as I said previously, the legislature has this opportunity to look at individualized sentences, to respond to Miller, and like California and like Delaware, to adopt a fair decision that affects everybody, not just one that says, okay, too bad, it's not retroactive, and that's why a retroactive solution is critical too.
Thank you. Hearing no questions, thanks for your testimony this morning.
Thank you very
this
much.
afternoon.